Coffee Breaks with Becky. I'm Becky, and this is the show where I answer your family law related questions. And this morning we're going to be talking about can a child say where they want to live, and will a court listen? This actually is a question from my Instagram account, and somebody sent me a question through Instagram. So if you have questions, you can send them to me there. The question was, what age does the court listen to a child on which parent they want to live with more often? So first I have to say that the laws are different in every single state. So while I can't say what your state says, what the laws are in your state, I can say that I can give some general ideas. If you are truly curious about what the laws are in your state, I highly recommend you go contact a lawyer in your area and get that question answered specific to your case. What I'm going to be able to tell you is what I know based off of California and actually a little bit of research I've done in Oregon. So this is not legal advice for your specific case. This is just general information about children and whether they really should be allowed to determine where they live. So this actually is one of the biggest questions I get asked is, my child wants to live with me more. Or when can my child decide? Is it age 12? And for some reason people seem to think it's 12 or 13, that the courts will, it's for sure the courts will listen to your child when they're 12 or 13. That's actually not the case. Or has not been my experience of the case. So the thing to remember is that kids typically want to love both parents. And the younger children don't have a fully developed sort of emotional understanding of what's going on. And when they're with you, they tell you, I love you, I miss you when I'm not here, I want to be with you all the time. And in their minds, that's very much true. But then they go home to the other parent and they say the same exact thing. I love you, I miss you when I'm not here, and I want to be with you all the time. Which again is true, because they just don't understand the full concept of all of that. So both parents may think, oh, my kid wants to live with me all the time. But your kid just wants to actually make both parents happy. They want to love both parents. So that's partially the reason why courts don't put a lot of weight on younger children, because they don't make more mature, well-reasoned choices when it comes to their welfare. Because they don't have that mental capacity to do so. So the other thing little kids, younger children, and sometimes even teenagers can use when they're deciding where, if they get to decide where they want to live, is, oh, Dad lets me play video games all the time, or Mom only lets me play for half hour a day, or Mom lets me eat whatever I want and Dad makes me eat a stricter diet. So it could be a situation where a child thinks they're going to have an easier time or less rules or something at one house, where that's not necessarily in their best interest. It's not, the examples I used aren't good or bad, but I'm just saying, one parent may enforce homework rules where the other one doesn't, and so the child is going to want to go to where the homework rules aren't enforced, perhaps. And that's not the best reason to change where they live. So one of the things that, as the kids get older, they can make more mature decisions. So the closer they are to 18, the more likely that, they can make more mature, more rational decisions that make sense as to their general welfare. Courts look at everything. They look at both parents' households. If there's a household that's a party atmosphere and kid won't have any rules and kid wants to live over there, that's not necessarily in their best interest. So the court probably won't honor or give much weight to that. So it's the standard seems to be, and that I've found so far, is that it's what's in the best interest of the child. And that really should be your standard as well. What's in the best interest of your child? Courts don't really like to make kids testify in court. because you've got a child who now has to say, pick one parent over another in front of both parents, and that's just not healthy emotionally for a child to be put through. So there are ways, though, that the court will listen to a child's preference, and their cost. Some of them are pretty costly. A full custody evaluation is where there's a custody evaluator. That's exactly what they do. They evaluate every single aspect of the child's life: mom's house, dad's house, school, every single thing. And they put together a report, and in that report they interview the child, and so they will put in there what their interview with the child, what happens during that interview. So that's one way to get your child's voice heard if you think that's important. Custody evaluations can start around $10,000. That's just for the custody evaluation. That's not your attorney's fees on top of that. They're very costly. Another is if the court assigns an attorney to your child, also costly because both parents have to pay for that attorney. And then that attorney interviews your child and the school and all this stuff, and same just interviews everybody, because the attorney is representing your child and what's in your child's best interest. And see, there it is again, what's in the best interest of your child. So this attorney is now the judge. For some reason, if the judge assigns an attorney to your child, it's because the judge maybe thinks that neither parent can clearly see, or the judge can't tell what's in the best interest of the child, so they assign an attorney to that child, and that attorney will write a report after doing a bunch of interviews with your child, with schools and etc. And your attorney the child's attorney will present a report based on what they find on what's in the child's best interest. And so that's another way your child's voice can be heard. If your child's in therapy and the therapist is willing to write a letter or testify in court, that's a way to keep your child out of it. Therapists are typically a good unbiased towards either parent party, and if they're willing to get involved in the court, if that can be helpful, and keeps your child out of court or having to testify or anything like that. And then another way is that the judge can bring your child into their chambers and talk to them one-on-one with no attorneys and no parents around, just the judge and your child. And then the judge can get a feel of what the child wants and if it's based in anything that makes sense to the judge. So those are there's not really any hard and fast answer about when your child gets to choose, or even if, where they live. Work with your co-parent as best as you can, and do what's in the best interest of your child. If you need an attorney, go because you need more time with your child, or you feel like your child's best interests aren't being met, then I would just highly recommend go hire an attorney. If you're in California and you need an attorney, you can give me a call, 707-532-5789. You can also text that number. I offer a 30-minute free consultation, and so if you're looking for an attorney in California, let's talk. You can visit my website at www.abrahamfamilylaw.com for more information about me and my law practice. Follow me on all my social media sites. Send me your questions there. I'm on Facebook and Instagram at Abraham Family Law, and I'm on Twitter at Abraham Family LA. And then, of course, YouTube. You can post a comment below this video. Just get me your questions. You can email them to me also at Beki, Beki, at abrahamfamilylaw.com. And just let's talk. And if you send me a question, I will answer it on an upcoming episode, just like I answered this one from Instagram today. All right. Have a great day and enjoy your coffee. Talk to you next week.